due to start at 5 past?
Yes.
Yeah.
Deal with that. It's not what it sort of says. The head nature. Well, I haven't read it properly, which is basically possible.
All rise.
My Lord, I was just coming to the end of the criticism that the judge didn't consider whether or not what Mr. Langdon said he would do, or that those under him would have done, was appropriate. And I just have to make one more point on that, which is that, I mean, obviously I've said that the judge had considered that, given all the information she had before her, the submissions and how it was dealt with. But my learned friend invites you, of course, to substitute that decision with a decision that it was not acceptable what he did. And we've covered this ground already, so I only need to just identify it, which is the basis of that was Mr. Thorpe's evidence that it would be wrong for an A&E department to reroute, an orthopedic department to reroute to A&E if it was a follow-up case. So he's accepted that it's acceptable for an orthopedic department to reroute to an A&E in any other circumstance. And I'm not going to rerun the arguments about follow-up, which we've addressed at length in the morning, but the same applies. And you'll remember I did make the submission that Mr. Thorpe's position was itself illogical. And in contrast to that, there's Professor Fairbank's evidence, which was perfectly firm and clear, and his hospital would send patients such as Mr. Hewes to A&E. And we've reviewed that evidence as well. So I don't say anything more about it, save to say that if in all the circumstances it was considered that this judge had not considered that part of the test, which he was encouraged to do so, then this court can with confidence conclude that what was being suggested was entirely appropriate in any event. My Lord, so that's the end of the grounds of appeal. And I just want to take stock 20 seconds just to ask where we are in terms of the allegations of breach of duty against the third defendant. Because it's important to remember that where we are now is the claimant's case is that it's totally acceptable for a GP, an out-of-hours GP, to send a patient to A&E. So no issues about MRI scans, no issues about delay, as long as that as long as that patient is not a follow-up patient. So that's my understanding. So although we've inevitably looked at all the underlying factors, if you start from the starting point of the claimant's position as it now is, referral to A&E is perfectly acceptable. The magic twist in this case is that this claimant was described as a follow-up patient. Not a follow-up patient to Watford, definitely not a follow-up patient to Dr. Tanner, but because he had had previous treatment in another hospital meant that Dr. Tanner was mandated to send to orthopaedics. Where Dr. Tanner was to find that information and guidance from, we're at a loss. But it said that's the basis of his criticism. It's very narrow. And on that basis, we would say the judge was entirely right in her conclusions. And I say no more about the grounds of appeal. My Lord, that leaves one matter in my now 8 minutes, which are the timelines that have been provided. And my learned friend has provided 3 timelines for different scenarios, and he indicated yesterday that they speak for themselves. Well, I'm not sure that they do, because, and it's not entirely sure what the Court of Appeal is supposed to do with these timelines, because these are the breakdown of 15 or 16 steps, some of which have assumptions in them which aren't supported by any evidence at all, some of which have matters which were disputed at trial, and the judge gave a ruling on them, but the claimant doesn't adopt that ruling, and others are matters in dispute which the judge didn't rule on. And my Lord, we struggle with how the court is supposed to deal with them now. I don't think the court is being asked to do that exercise, but it does seem to us that the claimant has to establish that if he succeeds on all the other grounds, that he can establish this will get him over the his 3 o'clock deadline. And we have to say the argument for that has not been made, and we would say that if one looks at the timelines, one can very easily see that's a perilous position. Before, and subject to whether I do have time to do so, I just want to say something about approach on timing. My learned friend is going to deal mainly with this, and we are not duplicating submissions almost entirely, but here there may be a little bit of overlap, because the third defendant does just want to emphasize that the test here is reasonableness. Things have to be done in a reasonable time. That's the test and nothing else. And that allows all conduct and timings to be considered in all the circumstances to test that reasonableness. There is a danger in providing an alternative test in specific circumstances, saying, so here the test is this, because either it's exactly the same test, in which case one might as well stick with reasonableness, or it's a different test, and then you're applying the wrong test. So all the formulations that are being advanced by my learned friend are dangerous, and the judge's analysis at 36 is spot on. And how to consider what is reasonable in a particular case in terms of timing will of course vary from case to case. A judge has to decide how he or she wishes to approach it, because one can see that if it's a case where the delay is pressing an emergency buzzer in an obstetric situation with all the staff around the mother, one can perhaps admit that with precise analysis in matters of minutes and seconds. But here we have 7 to 8 hours of a pattern of events in a district general hospital is not amenable to the same analysis. And one gives a simple example. One of the steps is the 3 to 4 minutes it takes for a clinician to walk from A to B. Well, it might be right that is how long it takes if you walk directly from A to B. What we don't know is if that clinician is walking along and a junior doctor comes up with a query and asks, and he takes 3 minutes to deal with that, and then carries on his way so he can address the problems of Mr. Hewes. I mean, those are the things that happen in district general hospitals. We don't know whether, I mean, being facetious here, but if when the doctor is called to go to Mr. Hewes, he needs to pop to the loo on the way, that, that means the 3 to 4 minutes doesn't work anymore. you can't take this whole pattern of period of time and start breaking it down into minutes here, minutes there, when these aren't precise elements. This is why the judge was right to test against her other findings, the overall timings here. In terms of the timeline, my lords, I think I have a few minutes, and I will invite your lordships to turn up our timeline, which is at tab 7 of the. Sorry, is that a wrong reference? Call bundle tab 7. Yeah, that's it. The claimant's ones, exactly. Sorry, I'm sorry, it's not a wrong reference. Page 89. One starts the timelines. The one we're interested in is table 2, succeeding against D3. And I've already indicated that there are various anomalies in this, but I just want by way of example, just so the court understands, if I may put it that way, the sort of problems that arise on this analysis. The first is if we can look at step 3, the ambulance arrives at Watford at 8 o'clock in the morning. Well, that's the time that it did arrive, less than 90 minutes for D2. But the difficulty here is if the claimant succeeded against Dr. Tanner, that means at 6:15 there's been a telephone call to the orthopaedic department. That will have taken some time, we don't know how long. He's had to explain the position and then get instructions from the orthopaedic department. We don't know whether it's going to be exactly the same. Mr. Thorpe, in his report, indicates the call may say, well, go to a different hospital altogether. So you've got to wait to find out what's happening from the orthopaedic department, if that's the route you're going to take. That is simply ignored. At step 6, it said that Dr. Kirkby would have examined at 8:23. Well, the pleaded's case was 8:30. Mr. Thorpe initially said 8:30, and then in the joint statement he said it depends on who's available at the time. The defendant said not before an hour earlier, which would have been 8:50, and then Mr. Cowie said not before 9 o'clock. Well, I don't know how this court is supposed to deal with that at all. Then in terms of into the scanner, 13 and 14, it's just assumed that if you can fast forward the time for the GP, that as they have done here, that everything moves forward. Well, we don't know whether that's right or not at Watford. It doesn't simply follow that you can bring everything forward. We don't know anything about how that is analysed, and there's no argument provided. At step 15, what seemed to be agreed in the evidence that it takes 10 minutes to upload the scans, and then 10 minutes would be reasonable for a doctor to review. Dr. Langdon said, well, of course, it's possible the surgeon goes down to the scanner and waits for them to come, and he's there immediately. Then he can review in seconds. So they take the 10-minute time. And then the compression, the decompression elements, so that's the beginning of the surgery to when decompression is achieved, are listed at 30, 45, 60 or 90. The judge found it was between 60 and 90. There was an exchange about it yesterday that the actual operation took 2 hours. You can take 30 minutes off for closing up and all the rest of it. So the actual operation was 90 minutes. And we heard that Mr. Langdon, this would have been his first operation of this kind, and so he would have taken a fairly cautious approach. So, my lord, we can't resolve these issues, but all I would point out is that if you simply adopt an assessment by Dr. Kirby at 8:30 rather than 8:23, and you add in the additional time, they've missed out the time for theatre, which should be 60 plus 30 minutes, that's 15 and 17. You make those adjustments, we're after 1444, which means on their own case on legal causation they lose. So I'm not quite sure how the Court of Appeal is to deal with this, but my submission is, with only 4 minutes of looking at this, one easily gets to a situation in which you adjust this and you're after 3 o'clock. And so before the matter gets relisted for a trial on these issues, in my submission, that the court should have been persuaded that there was a very real prospect that it's worthwhile having another trial. Whereas at the moment, if it comes that I find myself in a second trial and I've got to lose 16 minutes to this to get past the claimant's own thing, I mean, I'll be able to do that, but I don't want to have this matter listed for a whole trial next year in front of another judge in order to do that in circumstances where this hasn't been dealt with in any way in either skeleton or oral submission. So it leaves a very difficult position as to what the status and how the court is supposed to proceed on these timelines. That's in respect of my timeline, and I'm not going to say anything about it.
2 more minutes, Stranton.
And that's it, my lord.
All right.
If there's anything else I can assist your lordship with, those are my submissions.
Thank you very much, Mr. Stranton. Ms. Hutton.
With the lecture.
My lord, may I start by adopting the starting comments of my learned friend Mr. Antalm in relation to Mr. Hewes' position and the effect of the injuries on him, and that nothing I say is intended to minimise that in any way, shape or form. Secondly, in relation to the appeal generally, when giving permission in this case, Lord Justice McComb referred to the fact that this was, in essence, a challenge to primary fact and challenges to evaluations of those facts. And as your lordships and ladyship will have heard, that is essentially what this appeal is about. May I also adopt what Mr. Antelm says in terms of the test? He took the court to the Perry case, which helpfully summarises quite a lot of authorities in recent years about how an appeal court is properly to deal with appeals on the facts. And Lord Briggs's conclusion that the constraints meant that it required a conclusion either that there was no evidence to support a challenge finding of fact, or that the trial judge's findings was one which no reasonable judge could have reached. And that applies not only to findings of primary fact, but it also applies to evaluative findings in the light of those findings of primary facts. Now, I won't say anything more because my learned friend has covered it. But here we have, and we can see this by my learned friend Mr. Booth's skeleton argument, paragraph 1. The attack on the judge's judgment and indeed how she dealt with the case, and it's a point that the Lord Justice Davis picked up yesterday, is very wide-ranging and fierce. We have at paragraph 1.1, it says at paragraph 1, the second sentence, there are 4 fundamental failings which undermine the judgment. And the first one is the factual errors which are in Appendix 1. Now, my learned friend Mr. Anton referred to those. I don't intend to take the court to them. I note that Mr. Booth didn't take the court to them. There is a list of 22 factual errors which the judge is guilty of in her judgment. We have put in an appendix in response which answers every single one of them. And the point that Mr. Anton has made and emerged yesterday was that the one that we conceded, we were in error in conceding about the 8 o'clock time in the morning for seeing the junior orthopaedic doctor. Otherwise, we have answered them comprehensively to say that she did not make the error that was alleged in each case. And my learned friend has not gone back on that. My learned friend Mr. Booth has not sought to gainsay that. Now, it might be said, well, he's got more important things to do. But this was one of the fundamental failings that undermined the judgment. And we've heard nothing more of it. And we've responded, he hasn't come back and said, no, actually, defendants, you're wrong about it. The second fundamental failings were said to be failing to deal with essentially the totality of the evidence. well, your lordships have got the point about Perry and all the other cases in relation to the totality of the evidence. The judge is presumed to have dealt and understood the evidence unless it's clear that she didn't do so. The third one, little 3, is the judge may, considering a case as suspected. This is the urgent versus emergency point. My learned friend has made it eloquently, if I may say so, where he finished that point with, I simply don't understand what their case is on that, because that was the agreed basis on which the claimant's expert, Mr. Thorpe, and the defendant's expert, Professor Fairbank, that it was to be urgent until the scan, and if the scan confirmed the position, it was to be emergency. Now, those might sound like semantics, because in everyday life, urgent and emergency may not be used, and may be used interchangeably. But what was meant by that, as we understand it, and it's illustrated by in Professor Fairbank's report. Can I take your lordships to that? And it is charcoal bundle, tab 14, page 131. It's the section from paragraph 41 through to 49. Perhaps I could just invite the court to briefly. 131 over to 132.
Page.
Yeah.
Page what?
131.
Oh, sorry, did he? Oh, I'm told the judge cut out those paragraphs.
My lord, I hesitate to rise.
I didn't realise that.
Sorry. In the course of the exchanges when Mr. McLeish was opening the case to the court at the start of the trial, he raised issues about Professor Fairbank treading into areas of breach of duty, which he ought not to, as I understand it. And my understanding is that objection was taken to certain paragraphs.
Which paragraphs?
My understanding is 27 to 35 inclusive, 37 to 39 inclusive, 45 to 49 inclusive.
I see. Okay. Well, I'm sorry, I didn't know that. It wasn't marked in the appeal bundle. The essence of the point is, and it's a point that has emerged before, is that a large number of people who are suspected of having cauda equina go for scans and don't have the condition. And therefore, it would simply overwhelm the hospitals who, even in Watford General Hospital, which, isn't a huge hospital in the scheme of the hospitals in England. You've heard about the numbers, about 800 a year. If they all had to be scanned, if they all had to be dealt with on an emergency basis as soon as they emerged, as soon as they came through, then it would overwhelm the hospital. There has to be an assessment first about whether the patient is exhibiting the signs which merits an MRI, and then the MRI has to be done. And as soon as the MRI confirms the cauda equina syndrome, then it is an emergency. But you can't, and it's a logical position, as Lord Justice Davis said yesterday, this is a logical distinction. That doesn't mean that you move slowly before the scan, but it means that you move even more quickly after the scan if you happen to be one of the minority of people that actually have the condition.
We know that there were 800 a year.
Yes.
Do we know how many CES cases that translated into?
No, I don't believe so.
I have a record 80% not.
As a general rule, 80% not. I can't answer for Watford General Hospital out of that number, but as a general rule, 80% don't. Yes. Now there was a there was not only a logical basis for this, but it was agreed between the experts. So how it can be a fundamental failing, one of the 4 fundamental failings, which undermines the judgment in itself, is difficult to understand. And the 4th failing is it said that the judge failed to make any reasoned determination on the central issue in this case, which was that in considering suspected CES, time is of the essence. The standard in relation to both breach of duty and factual causation is that treatment must be provided as soon as practically possible, and it is illogical and unreasonable to fail to do so. So that takes us on to paragraph 36 in the judgment. And the suggestion that the judge has got the test wrong in paragraph 36. Page 313, if it's in the blue bundle. What the judge found in relation to this, paragraph 36, in the context of the present case, the claimant's hypothetical alternative timelines, it is agreed between the parties that the court should be guided by what would be regarded as the reasonable in which particular steps might realistically be taken, as opposed to the minimum achievable. Mr. McLeish, on behalf of the claimant, invites the court to consider with care what this means in an emergency. Now, the court asked, well, she says it was agreed. Was it not agreed? We had understood that it was agreed. If one goes to the charcoal bundle, at the end of tab 1, sorry, I'm in the wrong bundle. It must be. Just trying to find the paper that went in yesterday. Which bundle did it go in? Transcript. Oh, the transcript one. I'm sorry, the grey bundle. Thank you very much, Trish. Supplemental to the grey bundle. Grateful. There is inserted yesterday at the end of tab 1, page 25A and 25B. And this was a note done by Mr. McLeish immediately before trial in response to the defendant's skeleton and helpfully trying to narrow issues for the judge. And you've only got the front page and then the third page. Paragraph 8 says this, under the heading, standard to be applied to the hypothetical timeline. D1 and D2 submit that the assessment of the hypothetical counterfactual timeline should be guided by what would be regarded as reasonable and not the minimum achievable. Claimant agrees with this, subject to the caveat that reasonable in this case is what is reasonably achievable in the context of a surgical emergency, in which time is of the essence and whether reasonable timeline stands up to logical analysis in the claimant's specific circumstances. Now, the way the
was this submitted to the trial judge's document, or was this submitted to Master Cook for case management?
No, this was to the trial judge. This was on the first day of the trial.
We have a date. The date is the first day of the trial.
19th of March.
19th of March 2019. Now, we understand that this, together with Mr. McLeish's adoption of that in oral submissions, is the basis for the judge's paragraph 36. It is agreed between the parties that.
It does echo his language.
Yes. It doesn't say as soon as reasonably practicable. Effectively, what it says is reasonable, but in the context of an emergency, which is what the judge notes at the end of paragraph 36. It appears that Mr. Booth is putting forward that somehow a different test should apply, and he did say that he disagreed with paragraph 36, but it's difficult to see how in the light of that note. And we say that the judges, and Mr. Anton has dealt with this, and so I'm going to be dealing with it very briefly. The judge's approach of adopting reasonableness, even if it wasn't agreed, which we thought it was, and the judge thought it was, is absolutely right. As soon as you start adopting a different test, as soon as reasonably practical, you get yourselves into the difficulties that Mr. Anton suggested. An example of that, Mr. Anton gave the example of the doctor in the 3 to 4 minutes it takes to go to the radiology department being contacted by a junior doctor about another case, which in the context of the District General Hospital must happen, in my submission, perhaps giving evidence, but it's fairly obviously all the time, that kind of thing. What is, if the test is as soon as reasonably practical, does that take into account that conversation that might take place?
Well, sometimes reasonableness in a case of emergency might mean that acting reasonably, you tell the junior doctor, I'm very sorry, I can't stop to talk to you, I'm in the middle of an emergency.
Absolutely, that's absolutely right, if that's the right thing to do. But what happens if that case is an emergency? If that other case is an emergency? I really need your advice quickly about X, Y, and Z because this patient is going south on me. Then you get into arguments where you haven't really moved as reasonably as practically possible in both cases, because you can't. That's why you get into difficulties in this 3 to 4 minute breakdowns of 18 steps, and why you have to stand back and go, how long did it take overall? That sounds reasonable in the context of it.
Would you agree with Mr.
Yes.
Booth's proposition that simply, say, taking a time frame overall of 6.5 hours is of itself reasonable? It does not necessarily follow that within that.
Oh, yes, I entirely accept that.
You
yes.
accept it?
No, absolutely.
You do accept that.
If you're able to say, well, actually, although I've allowed an hour for this, in fact, it doesn't take that long, or it doesn't take that long, or what, because of X, Y, and Z. Absolutely, I agree with that.
So the fact that the expert for the claimant, in broad terms, accepted 6.5 hours isn't of itself fatal to the case, because within that, you can still have a requirement on a yardstick of reasonableness to move quicker.
He accepted that the time spent was reasonable. We say that that is the question the court had to determine. Was it a reasonable time in the circumstances?
It's quite important to say in
Absolutely.
the circumstances.
I entirely accept that. Yes. And that's why the caveat of this was a surgical emergency, certainly from the actual diagnosis on the scan, is absolutely right, and we have no argument with that.
Or even before the scan, it's urgent.
It's urgent, absolutely. I entirely accept that. It's urgent, but it's always reasonable. Reasonable in the context of an urgent position. Not as soon as practically possible, because you get into all those difficulties which Mr. Anton and I sought to highlight. And it is different to the obstetric case, where there's, for instance, there's a cord prolapse, which is a very serious condition where the baby's cord, the fetus's cord, falls out, and therefore the baby's getting no oxygen at all. The midwives are there, the registrar might be there. You've got to get that baby out as soon as possible. You haven't got any other cases to deal with. You're not going to be stopped by the SHO and say, oh, I've got this case. You are there. You can analyse that in terms of minutes and say, well, actually, they took too long to get the baby out, given they were there. But this is very different to a process over, minutes and hours, which we're talking about, walking from one department to the other, walking to discuss it with a consultant radiologist, as we'll come on to. How long does that take? Do you have to queue? There's a discussion about the fact that often when you go to the radiologist, there will be a queue and you've got to wait. Or you've got to try and force your way. Actually, I think I'm more urgent than you before you get to the... So there is a real danger in setting this down into blocks of 3 minutes and saying anything longer than that, not as soon as practically possible. And so we say that the judge has not gone into error in paragraph 36. She's absolutely right. There isn't any authority that Malone and Friend has cited for this point, that the test should be as soon as reasonably practical. He seems to rely on Belitho, but I'm not sure how Belitho helps him in this context. It imports the need to consider whether that any time delay is logical, which is uncontroversial, but I'm not sure that it imports, well, I suggest it doesn't import, a test as soon as reasonably practical, where the litmus test of negligence, the tort of negligence, is always reasonableness. Reasonableness in the circumstances, absolutely, but reasonableness.
Well, this gets very semantic, because so long as you've got the word reasonable in somewhere, you would have thought it'd be all right.
Yes. Well, it's
as soon as reasonably practical,
yeah.
The heavy lifting can be done by the word reasonably.
Yes. Yes, but ultimately the question is reasonable. And it is the fact that the claimant takes issue with paragraph 36, yeah, which is why I'm addressing this point. So then, in relation to appeal ground 1, that doesn't relate to me. That's Mr. Antelm's client, and I say nothing on that. In relation to appeal ground 2, that's factual causation against the third defendant. So it does not directly affect me, and I'm not going to repeat anything Mr. Antelm says. It affects me indirectly, my client indirectly, in the sense that there then comes the issue about how long things would have taken if Mr. Hewes had gone to the orthopaedic department straight away rather than A&E. But I don't wish to say very much about that at all. Mr. Antelm has dealt with that. Apart from the suggestion in the skeleton, but it hasn't been repeated orally by the claimant, that
as I said, the fact that something in a skeleton has not been repeated orally does not mean the point has been dropped.
Absolutely.
We have to move with some speed here.
No, I do accept that. Absolutely. And it's the suggestion that they didn't know. They believe that Dr. Kirkby would have been the orthopaedic doctor around at 6:15 in the morning to take the hypothetical telephone call. And Mr. Antelm has dealt with that. What I would say from the first defendant's point of view is that no one ever asked us who the doctor would have been. My learned friend, Mr. Booth, complains about the fact we didn't know. We assumed that it would be Dr. Kirkby. Well, no one had ever said it was Dr. Kirkby. And you have the point, and it's a point that was made in the Master Cook hearing.
Well, I'm not sure this really matters very much. The trial went ahead.
Yes.
On the basis the judge had to deal with it on the evidence as is before her.
Absolutely.
I mean, no one asked for an adjournment or
Nope.
made further applications of disclosure or anything like that.
No. And I would just say that this is a theme that the claimant has, and we'll come on to it a number of times. They complain that they haven't got the evidence for something, or that they were ambushed by something, etc., what the experts said about pathophysiology, etc., about various matters. But the reality is that in relation to Dr. Kirkby, and in relation to, we'll come on to the MRI patients, the 2 other MRI patients, where they say that the claimant should have been prioritised over those 2, the cancer patient and the cord compression patient. They never asked for the notes of those cases. Not once. If they wanted to compare and contrast the urgency between Mr. Hewes and those other 2 cases, they could have asked us for the medical notes. They never did. Not only did they not ask them before the trial, they didn't ask for them at the trial, which they could have done. We could have scurried around, found them. We had the patient numbers for them because they appear on the MRI documents. We would obviously have had to redacted their names and personal details, but it could have been done. But they never asked. If we'd have been difficult about it, they could then have applied for specific disclosure. They never did. And then they don't complain to the trial judge, they come to the Court of Appeal, to this court, and say, oh, it was very unfair, you never told us this, when they'd never asked for it in the first place. We suggest that that's not the right way of going about it. So, factual causation, I'll come back to the timelines, which my learned friend, Mr. Antelm, finished his submissions on, because we have some matters in common in relation to that, and move swiftly on to the first ground of appeal that does directly affect my client, which is ground for adverse inferences. Now, the claimant advances what we've called a lengthy critique in relation to this, to say that the judge was wrong to make findings on the basis of Dr. Mackenzie's witness statement, where Dr. Mackenzie, of course, was in Australia and did not come and was not cross-examined. And the way that it was put yesterday orally, and I made a note of this, was that the sole evidence that there had been a discussion with the radiologist about urgency in relation to Mr. Hewes' case was Dr. Mackenzie's witness statement. Now, that is simply incorrect, and I'm going to, I hope, make good that point. There was a mass of evidence, not directly of the conversation between Dr. Mackenzie and the radiologist, because one would not expect, frankly, either the radiologist or Dr. Mackenzie, many years after the event, to remember that conversation or at least any details of it. But there was a massive evidence that in order to get a scan in the middle of the day slot, if I can put it that neutrally, the slot between 11:30 and 2, you had to go and speak to the consultant radiologist in order to persuade the consultant radiologist that your case was urgent enough that it required an immediate scan. So it wasn't the sole evidence. And where the judge, in her judgment, in its paragraph, I think 64, deals with this, paragraph 64 at page 321. She deals in that paragraph with the reasons for why Dr. Mackenzie didn't attend. But then says, just above the bullet points, that she requires her to approach the evidence with care because he's not being cross-examined. But I do consider that I'm able to attach an appropriate amount of weight to his evidence, not least for the following reasons. Firstly, the bulk of his evidence is broadly consistent with other evidence in the case about practice and procedure in the orthopaedic department at Watford General Hospital. It is also consistent with the available known timings. Secondly, Mr. Hewes' scan obviously was treated in accordance with the usual procedure, namely he was placed in the 11:30 to 2 slot reserved for inpatients for whom a scan had been requested that morning, i.e. urgent cases. He was listed next to 2 other urgent cases. The timing of the scan suggests urgency and by implication dialogue with someone senior with a consultant radiologist. And then the third point, which I'll come on to, is that Mr. Thorpe agreed that the actual timings were reasonable. Now, in relation to the first 2 points, what evidence was there that there was a discussion about urgency? Because it was common ground that the form which was filled out by Dr. Roffey requesting an MRI scan did not have any.
Did not have the word urgent.
Didn't have urgent. Didn't have cauda equina. You know, that form was not going to help very much. But the evidence was that you had to have a conversation with the consultant radiologist, and therefore the form was really neither here nor there. It was superseded by the discussion with the consultant radiologist in order to try and persuade him or her to allow for an urgent scan. Now, the evidential gaps which my learned friend for the claimant relies on are identified at paragraph 19 in his skeleton argument. He says at paragraph 19, page 69 in the core in the blue bundle, there were the following evidential gaps in D1's case. Firstly, urgent MRI scan. There was no direct evidence of any discussion in radiology and or the radiographer about the need for an urgent MRI scan. And 2, prioritization in the MRI list. There was no direct evidence of any discussion between orthopaedics and radiology and or the radiographer about the possibility of interrupting the MRI list or claimant's priority within it compared to those 2 other patients. Now, what is said to be the consequence of the judge's of the evidential gaps in that regard. But it's a little bit difficult to understand. But as far as I can see, the consequences are dealt with at paragraphs 32 to 34. And at paragraphs 32 says the claimant submits that in circumstances where the gaps in the timeline relate to matters which are part of D1's case that's argued at trial and arisen from its decisions in relation to disclosure and witness evidence, it is not appropriate for the judge to draw any inferences favourable to the defendant. I'm not sure what inferences were favourable to the defendant, not certainly in the terms of adverse inferences, but anyway, she made findings on the basis of the evidence. Paragraph 33, right at the bottom of certainly of my page 72, so the last sentence of paragraph 33, having rehearsed, just before it, the judge's judgment at paragraph 73, which is to the effect that it would have been helpful to have on the form a suspicion of CES and a request for urgency, but dialogue takes precedence over such matters. And the fact that he was placed in the urgent inpatient slot demonstrates that dialogue probably played its part. Then they say this: contrary to this finding, the absence of evidence on anything on the MRI form marking it as urgent, and in the absence of evidence of a conversation, the inference the judge should have drawn is that there was no discussion at all. That's what the finding the judge is said to should have reached. And then in paragraph 34, the last sentence again, in the middle of that sentence, it refers at paragraph 34 to the failure to say urgent on the, or CES on the form. And then the last 4 lines of paragraph 34, 5 lines of paragraph 34, the claimant was not treated as an emergency or given priority in the inpatient list after 11:30. It's more likely that the claimant was in fact just put at the end of the list, his request having been made last, he was scanned last, submits that this is a finding of fact the judge should have made, or in the alternative, it was a potential finding to which she gave no proper consideration in her judgment. So those appear to be the adverse inferences being sought. Now, in answer to...
When I speak for myself, I find it a little hard, I mean, it's logically possible, but a little hard to disentangle entirely ground 4 from ground 3. At ground 3, permission to appeal was refused.
Well, precisely, my lord. I agree. And ground 3 being all about the fact that she wasn't entitled to place weight on Dr. Mackenzie's statement. Yes.
They are capable of being distinct, but they run together a bit on the face of it. Well, at least I would have thought.
And there are paragraphs that were in the skeleton under ground 3, which have just been cut and pasted into ground 4 now, which rather underlines your lordship's point. Anyway.
But no doubt it can be said in the language you like to use, they are logically distinct.
In answer to the court's questions yesterday about what the claimant is asking this court to do in relation to adverse inferences, I think it was Lady Justice Laing who put to Mr. Booth, well, are you saying that no reasonable judge could have, that any reasonable judge was bound to find those adverse inferences against the defendant, first defendant? To which Mr. Booth said, no, I can't go that far.
I'm not sure I find this terminology of adverse inference very helpful. The point is, what inferences, if any, were to be drawn from the available evidence?
Yes.
And on one view, this is preeminently a matter for the trial judge.
Absolutely. No, I agree. I don't know.
Adverse inferences is to attempt to use that phrase in a different division of this court.
Yes. Yes. Well, it is the claimant's phrase, adverse inferences. So anyway, so I'm not sure if my learned friend is not saying the judge was bound to reach these adverse inferences, I'm not sure what he's saying the court should do about this. And I would be grateful for clarification unless the court understands. Because if he isn't saying that the court is that the judge was bound to make those adverse inferences, circumstances, then how does the appeal get off the ground on ground 4? Because surely that is the test. Anyway, in relation to the evidence, there is a mass of evidence about urgency of scan and how it was treated. Can I start by just very briefly...
The burden of proof in this sort of issue is on the claimant.
Absolutely. Yes. Yes. The first is Dr. Mackenzie himself, and his statement, and I'd ask you just to briefly turn it up, is in the charcoal bundle at tab 9, page 24. Can I just invite the court to read briefly paragraphs 7 to 12?
I don't have the
no, it's been edited. So that's all that we all have. If I could just ask the court to read 7 to 12.
Yes.
So, effectively, what Dr. Mackenzie is saying is, well, I can't recall, I would have gone and discussed with the radiology department, and I would have personally gone and spoken to the consultant radiologist, and I would have wanted an emergency scan, he says.
But in a way more importantly, the first sentence of paragraph 9,
yes,
for emergency scans to be done, a discussion is required.
Yes.
So this isn't a I would have, I might have. It's a statement of...
That is the process that you have to go through.
Yeah.
It's not just saying, as your ladyship says, it's not just saying, well, this is what I always do in this situation. No, you can't get a scan in that slot unless you do it. Then there's the evidence at the previous tab.
Just before you move away from that.
Yes, certainly.
He refers to interruption of the MRI list.
Yes.
My understanding was that he wasn't interrupted in the sense of put ahead of people waiting for a scan, but was put at the end of the slot between 11:30 and 2 after the other two patients.
Yes.
So in what sense is it being interrupted?
Well, I think it probably comes from the claimant's wording in the particulars of claim that it should have been interrupted. I'll come to that because that was an allegation. I did make this point during my own friend submissions yesterday. That was an allegation that the MRI should have taken place at 09:18 in the morning, which of course was in a different list. That was the outpatient list.
And that would have been an interruption.
That would have been an interruption, absolutely.
But Mr. Mackenzie would presumably have had no recollection of there being two other patients.
No.
I just mentioned that presumably in his witness statement.
No, he doesn't. So interruption is the claimant's terminology. In effect, well, the list should have been interrupted. In fact, as we come to the chronology, and I will come to this, by the time he's presented to the consultant radiologist, assuming he was, which we say is obvious because you can't get a scan without it, patient 1, who is the cancer patient, has already gone down for her scan. So he couldn't have bumped her out of the way in any event. He could theoretically have bumped patient 2, who was the cord compression patient. So actually, that's on the timings. That's what it comes down to. It is right that patient 2 wasn't bumped Patient 3, which is Mr. Hewes, arrived after patient 2 and was placed in the list after patient 2. That's right. And that is made clear in terms of the timings of the other patients by Ms. Devereux's statement, which starts at page 21, as in the previous tab. And could I invite the court to... she essentially introduces this on the basis that she doesn't have any recollection of this case. She probably wasn't involved in this case, but she just sets out the usual procedure. Could I ask the court just to read paragraphs 4 to 8 first?
Her statement was read.
Her statement, well, actually, her statement, Ms. Devereux attended on the basis that she was going to be cross-examined, and then it was decided by the claimant's side that they wouldn't cross-examine her. So she was called, adopted her witness statement in the witness box, and was then not cross-examined and left. On the basis of clarification of some issue.
Right.
But she wasn't cross-examined. They didn't challenge any of the evidence in this witness statement.
Yeah.
Now she has referred, and the claimant has tenaciously hang on to this point. She has referred to the middle of the day slot, if I can call it that, as being the inpatient list. And the claimants immediately said, well, this is not an urgent list, then it's just an inpatient list. That's all it is. There's plenty of other evidence, including from Dr. Mackenzie, which you've just seen, that it was reserved for urgent inpatients. But in any event, she sets out the ordinary procedure, which is you've got to get it approved by the consultant radiologist. That's how you do it. So you take the form to the consultant radiologist, you persuade the consultant radiologist to have the scan, and he or she signs it off. And then she deals then with the patients in particular. Paragraph 9, request 41336 related to the patient transferred from the gynecology ward. In my review of the trust system, the request was made for the scan at 11:11, and the patient's details were entered at 11:34. Possible cancer. And then paragraph 2, patient 41401, relates to a patient transferred from the acute admissions unit. Request was made at 11:30, and the patient's details entered at 12:21. And then paragraph 11 is Mr. Hewes. Request was made at 11:59, so one can see that he comes third in time, and a screenshot is attached, and he went to a request status attend status at 13:26. And then paragraph 12, she explains what happens when they actually go down for their scan. And then at paragraph 13, it explains that normally takes about half an hour. And then at paragraph 13, once Mr. Hewes had been placed in the MRI scanner, the first MRI image was taken at 13:33. So 7 minutes after he attended for the scan. Last image, 13:50. And then it explains that it takes about 10 minutes to put it onto the PACS system, in other words, onto a computer so that people can see the images. So
the indications in this report are that the other two patients were both treated as, in effect, urgent, because they were dealt with very speedily.
Absolutely, yes.
It probably doesn't matter. Do you know what cord compression means?
I will attempt to answer your lordship's question. So it is the spinal cord, which runs through the spinal column, can be compressed itself, and we'll come to this because there is evidence about it. In some ways, there is a similarity with cauda equina in the sense that it is a compression injury on nerves. But when you compress the spinal cord itself, then what can happen is that all motor and sensory can can be irreversibly damaged below the level of the cord, so that you can lose power in your legs. You can lose all power. Cauda equina is a serious condition, but it's not as serious as that, because usually its effect, and it's very nasty, but usually its effect is on bladder and bowel and sexual function. But although there can be mobility issues, you're not going to be paralysed with it generally, whereas cord compression can result in complete paralysis at all nerves below the level where the cord compression is.
Is the pathophysiological explanation the same? That if you compress the nerves, they can die after a certain... So it's capable of also being a time-critical condition?
Yes, although it's compression strictly of the spinal cord rather than the nerve roots coming out, but its effect is very similar, as I understand it.
But the important point is it can also be urgent.
It certainly can be urgent, and there was evidence about that, which I'll come to. So that was the witness evidence about what the procedure was for getting a scan in the middle of the day, and then there was a good deal of oral evidence about it. Can I come to the grey bundle, the supplementary bundle 2? And go in that bundle to page 141, which is after tab 9. And this is during the evidence of Dr. Roffey, the cross-examination of Dr. Roffey. And at the bottom of page 141 in the middle, from F, it's put to him just below F, and in fact there's nothing on the MRI form indicating the basis of the request for an MRI is suspected C, yes. On the form, the answer is on the form, that is, that's not there. You were taken to paragraph 12 of your witness statement earlier. The point arises from the way in which you were involved in processing the form that went to the MRI. Is there's no indication either on the form or in paragraph 12 of your witness statement that this was an MRI scan that was being sought with any urgency. Answer, correct, but there would usually be verbal discussions for CT scans or MRI, which would supersede largely what was on the form. So that's what Dr. Roffey said about it. Dr. Kirkby was asked about this. And if we can go forward in this bundle to page 160. The top of page 160. There's an answer. I imagine we were trying to prioritise getting the MRI then, documenting the discussions we were having between us. We certainly understood the urgency considering how quickly it was done. Question, cross-examination, there was no mention of urgency in the plan itself, is there? Answer, the urgency is in, and then it does not seem very urgent in the plan, the urgency is in how quickly an MRI was done within a district general hospital and acted upon. And then in the middle of that page, really as kind of flavour for the point of what was involved with these doctors, particularly junior doctors, at E, she says this, she says, no, I don't agree with that because you are seeing multiple patients. This isn't your only patient you're seeing when you're on call. And we're acting, we're prioritising, not sitting and writing every conversation between us, but there would have been multiple. You're getting an MRI done urgently, which is a process in itself. Then, on page 162, 162, at the top of page 162, but she says, but the patient had an urgent MRI based on the timings. And then she was questioned, what I'm trying to elucidate from you is to ensure that the claimant had an urgent MRI. And the conclusion I've drawn from what you just told me is, in fact, you did not take any steps to ensure that the claimant had had an urgent MRI. Well, I assessed the patient, examined the patient, and then relayed my findings urgently back to Dr. Mackenzie, which we have the outgoing bleep for. That is a bleep at 11:27. We have that bleep. She identified that as being a bleep from her to Dr. Mackenzie. Dr. Mackenzie then, as in his statement, urgently went to request the MRI, and at that stage, yes, it was escalated. And then further, at 168, at C, she says, just below C, there's a question, so about 20 to 30 minutes after you have finished your assessment of Mr. Hewes, answer correct. And that would have, the radiologist would have had, we discussed the scan with the radiologist, judge asked at what point to have the MRI requested, and they're located in another building. And then the judge asks a further question, just before anyone else does, would that discussion potentially have taken place on the telephone, or would it have involved walking? No. You have to walk to the hot seat where they sit, and often there is a queue to speak to the radiologist to get a scan done. And then she confirms that. And then at page 169, F, this is in re-examination, Dr. Kirkby. F, there's, and then what? A conversation has to be had. Answer, a conversation has to be had. If there is any doubt or they require further information, then you have to go away and get that. But otherwise, they will have a conversation with you, ask you the sort of appropriate negatives and positives, and then say yes or no and place the urgency on it. You then have to take the form to, and then she's clarified that she's talking as to what she's saying. And then over the page, at the page top of 170, and they'll, third line, and then they'll sign your form, and then you take that over to the imaging department, who then have to find a slot for that patient based on the urgency that the form's been given.
So does one infer from that that the urgency is attributed by the consultant radiologist?
Yes. And you effectively have to persuade the consultant radiologist of the urgency of your patient. And then so there was the evidence of Dr. Roffey that the form would be superseded by the discussion with the radiologist. You've got the evidence of Dr. Kirkby that has just been set out. You then have the evidence of Mr. Langdon, who was the consultant orthopaedic surgeon. And at page 178 in this same bundle, at D, he said this, just below D, the way that the scanning, the MRI, they had a gap in the middle of the day where we could get, actually this passage has been referred to before, we could get urgent emergency MRI scans done. I think it was between 11 and 30 and 2 or 2:30. So people were seen in the morning, they would get an MRI scan at lunchtime, people presented later, they would end up going to a different hospital. And then at page 179, so over the page, just below D, he was asked, so if there were no other emergency cases on the list, then Mr. Hewes' MRI should interrupt the list. I think that's the outpatient list. And he answers, in an ideal world, but in 2012, as I've said, the way the MRI service was run at Watford was that they had the middle of the day set aside for doing emergency scans. So they would, the radiologists and the radiographers would have tried, where possible, to get emergency scans to be done in that window. Although I completely agree that ideally they should interrupt the elective scanning list.
So the elective scanning list is the one in the morning?
Yes, from 9 o'clock.
Page 179, quite an interesting little discussion about urgent and emergent.
Absolutely, because Malone
It
Jr.
shows exactly what was
Exactly.
in everyone's mind.
And over the page 180, Mr. McLeish doesn't say, no, I don't accept that distinction at all.
Shortly put, I think what you were saying is that the judge is entitled to regard this as treated as urgent because it was treated as urgent.
Yes.
Has it not come down almost to that?
Yes, it must have been treated as urgent because
How
it
else
got
could this
in the
have
list. Exactly. And as for the inference to be drawn that there was no discussion with the radiologist, such a finding would be bizarre because how could the
How
scan
else
have
could
been
you get
done?
in? Yes.
Can I just go on because there's some more on prioritisation? Because we'll come to the prioritisation between the different patients. Going on with Mr. Langdon at page 185. The claimant's case, part of the claimant's case was that one of the errors here was that Dr. Kirkby, who was a very junior doctor, went to Dr. Mackenzie, who was the registrar. She should have gone to the consultant, Mr. Langdon, straight away, as soon as she suspected cauda equina. And the case was put largely by Mr. Thorpe, the claimant's orthopaedic surgeon. Look, if Mr. Langdon had been involved, you would have got a quicker scan because the consultant turning up and taking control of it would have made it faster. So that was put to Mr. Langdon, page 185, at between E and F. At 185E, Mr. McLeish says, Mr. Langdon, can I move on to ask some further questions about the specific case on the day? How could it have been dealt with? If you'd have been contacted by Dr. Kirkby, the urgent thing to do is to get an MRI scan, is it not? Correct. And that involves you talking to Dr. Kirkby and obviously contacting the radiologist yourself. That is something that you would have done in those circumstances. Answer, I think it is impossible to do something about which you know nothing. If I was unaware of the patient, I think I would have been expected to go and communicate with a radiologist about a patient I was not aware of being in the building. So it's a hypothetical question. But then towards the bottom of that page, he said, last 4 lines, if that were the case, forgive me if I've been misheard, then I don't think anybody could have got an MRI scan accepted any quicker than the MRI being accepted at 11:59. Recall that Dr. Kirkby's message to Dr. Mackenzie was at 11:27. So Dr. Mackenzie had got there and got the whole thing accepted by 11:59. Bearing in mind that it would have involved leaving where the patient was, going up to the radiology office, potentially fighting your way to the front of the queue, getting a signature and going back to the MRI scanner. I struggle to see within those timeframes, forgive me if I misunderstood them, how anybody could have got that scan accepted any quicker. And then he goes on about the fact that there were other patients in the hospital.
The 11:27 bleep.
Yes.
The bleep record doesn't actually say which patient it's about or who makes it. What is the actual record on the bleep record? What do we actually know?
We know that it came from a number, I think in A&E, to the bleep that was owned by Dr. Mackenzie. So we know it went to Dr. Mackenzie and we know it came from A&E. We don't know that it was Dr. Kirkby that sent it, I think, but Dr. Kirkby gave evidence that it would have been her. So that's the evidence we have. We know that he received the bleep from A&E, and that it fits
at
11:27. At 11:27.
And by 11:59, Mr. Hewes had been accepted on the scan list.
Exactly.
So the judge is making an inference based on that and Mr. Mackenzie's evidence, Dr. Mackenzie's evidence is what he would have done.
Yes.
That it was in relation to Mr. Hewes. The 11:27 bleep was in relation to Mr. Hewes, and he then went to the radiologist and got it put on the list.
Because you couldn't have got that scan without going to the consultant radiologist. That was how it was done.
So far as the weight to be attributed to Dr. Mackenzie is concerned, his statement did in fact have some support from Dr. Kirkby and Mr. Langdon.
Yes, absolutely.
As to practice.
Absolutely, yes, as well as Ms. Devereaux about the standard practice of getting scans.
Yep.
And then on the bottom of page 186, dealing with prioritisation, the judge at F says, but I think that part of the question, it was 2 questions really. The part of the question that you were asked, Dr. Kerr, it was that if Dr. Kirkby had come to you, this particular presentation for your guidance, you would have called the radiology department and as a consultant, perhaps been able to expedite matters more than the junior doctor. I think that was the point that was being put to you. Answer, I am not. Knowing what we know about the day, I'm not convinced that it would have made any difference under the circumstances because of the timescales. And then over the page at the top, Mr. McLeish says, well, I understand that point you made about the timescales, Mr. Langdon, but if Dr. Kirkby had come to you with Mr. Hewes' case, there was a need for an urgent MRI, would you have contacted radiology to make sure it was undertaken as quickly as possible? I suspect I would have asked her to arrange it and let me know if there were any difficulties. Looking at what happened, I'm not. I struggle to see how we would have delivered it any quicker, bearing in mind the other urgent case that was also scanned beforehand. And if you asked Dr. Kirkby to arrange the scan, you would expect her to do that as soon as practically possible, would you not? Answer, yes. If she had come back and said they will not agree to it, the radiologist is being difficult, they will not do it urgently, then I would fairly certainly that, yes, I would have gone. They are different. Very difficult, sorry. Etc. So the evidence was that by Dr. Kirkby went to the registrar, Dr. Mackenzie, who went up and arranged what Mr. Langdon thought was an incredibly quick scan. If Dr. Kirkby had gone to Mr. Langdon would probably have said, Dr. Kirkby, you go. And you sort it out. Well, Dr. Kirkby was an FY1, I think, first year out of medical school. So she would have been even more junior. So the concept that would have sped up the process, of course, was shot at that point. She wouldn't have done. And Mr. Langdon would only have gone if Dr. Kirkby had said, the radiologists just aren't convinced this is urgent enough and they're not going to scan today. So the evidence was extremely adverse to the claimant's case. And page 188 over the page, at just about between B and C, Mr. Langdon is asked about Dr. Mackenzie's statement about going to radiology, and Mr. Langdon responds, in order to facilitate urgent diagnostic, not just in Watford General Hospital, but as far as I'm aware, pretty much any hospital, you have to go and speak to a consultant radiologist. If you want something done on an urgent basis, it needs agreement from a consultant radiologist.
I think we got the point. Anything else on ground floor?
No, thank you. So, in terms then of the invitation that the judge should have found that there was no such discussion, we say that's just hopeless on the basis of that evidence. There was a wealth of evidence that it would have to have taken place. As to the second point, which is the prioritisation point, it's worth bearing in mind, and this is the prioritisation within the three patients, the cancer patient, the cord compression, and Mr. Hewes. The pleaded case, I pointed this out yesterday, but it's in the particulars of claim, was that the scan should have been done by 0918. So that didn't involve the urgent patient list, it involved interrupting the outpatient list. The pleaded case never changed. It remained 0918 as far as 0918 as far as I'm aware. We then served the witness statement from Ms. Devereux in April 2018, which I've taken the court to. There was never any request for disclosure of the medical records of the cancer patient or the cord compression patient. The evidence was, and it's evidence that comes out in the oral evidence, quite apart from the expert evidence, is that actually the decision for prioritisation for scans would have been one for the radiologist to make, not for the orthopaedic surgeons. So if they wanted to go down the road of alleging, if I can put it in this rather ugly shorthand, negligent prioritisation, they would have to have first got the records for the two patients, and then got a consultant radiologist's view on whether it was reasonable that Mr. Hewes came third.
But it wasn't their pleaded case.
Wasn't their pleaded case, and they didn't do it, and they never asked us for the records.
And you did also have evidence from Mr. Laing, I think, that cord compression could be more serious than cauda equina.
Yes, as you saw, it is from the same page.
It's
It's
on the same page.
186.
186. Yes, sorry, should have come up with that.
B to C,
Sorry, 186.
B to C.
B to C. Yes, sorry. 186. This is the prioritisation case. At just above B, we also have to consider that there were other patients in the hospital, and that, as you know, as I think we said yesterday, the patient who was scanned before had query spinal cord compression. And whilst the implications of cauda equina syndrome are serious, one would argue that if somebody had potential spinal cord compression, that is more likely not just to affect the cauda equina nerve roots, but can affect the arm and the leg function as well. So I think they would be triaged as a higher priority than a query cauda equina syndrome. And potentially both of those patients may have been sitting under orthopedics. I don't know who the other patient was.
He says it again at 188.
And he says it again at 188. At D. He says a potential cord compression is a greater emergency than cauda equina syndrome. Now, my lord, the claimant's skeleton has a reference in relation to adverse inferences to a case called Keith, which is in the bundle. He didn't take the court to it yesterday, but I entirely accept that doesn't mean that he places no reliance on it. In the light of what Your Lordship said, it's difficult to characterise this as an adverse inferences case. But if we go to the case of Keith, which is at tab 4 in the authorities bundle, it was a very different type of case. Decision in 2010 of Lady Justice Arden, Lord Justice Longmore and Lord Justice Akins. And at paragraph 2, it sets out the brief history of the matter, that the claimant had spent his working life as a seaman, working mainly in ships' galleys, and he worked for various employers at various different times. And then he had an audiogram which showed 22% hearing loss towards the bottom of paragraph 2, which 50% was held by the judge to be attributable to noise. No evidence of noise suffered at any other times other than in the course of his employment with the defendants. There is at paragraph 5 a setting out of the fact that there was an obligation to for his employer to record noise levels, clearly known as a noisy occupation. And at paragraph 6, this case is, as the judge said, somewhat unusual because there is no engineering evidence of noise level in the ships, which Mr. Keith served during his 20-year period of employment with the defendants. There is no evidence that the defendants took any measurements of noise levels in their ships, and the judge's finding is that they did not. They were, however, aware of noise problems and that they provided ear protectors for employees working in the engine room and also for a short time to employees working with cars coming on board and leaving ships. But it does not appear that occurred as a result of any noise measurement being taken. The relevant ships were all disposed of before the claim was brought. Short judgment, the judge had dismissed Mr. Keith's claim because, as he put it, he was exposed to in order to prove his claim, he had to be exposed to periods in excess of 8 hours of noise levels above 85 or fluctuating noise of an equivalent of 85. He held that she could not prove, that was the wife, the widow, could not prove that that was the case, even though he was satisfied that Mr. Keith was exposed to excessive levels of noise, sometimes in excess of 90. He could not, however, find that there was exposure to excessive levels for 8 hours and dismissed the claim. Judge recorded the shipbuilders 9 at 8 were in breach of duty in failing to make noise assessments. they're a principal witness to the fact Captain Krellin was embarrassed by his failure, but he gave little weight to breach of duty. And there was also other evidence of the fact that people had to make hand signals to each other because it was such a noisy place. Paragraph 18, if matters had rested there, breach of duty, if matters rested there, it might have been difficult for this court to reverse the judge on what is, at any rate, primarily a question of fact, namely whether excessive noise in the course of Mr. O'Keefe's employment causes undoubted hearing loss. However unsure this court might be that the judge had reached the correct conclusion, but in the present case, there is a potent additional consideration that any difficulty of proof for the claimant has been caused by the defendant's breach of duty in failing to take any measurements. The judge appears not to have given any weight to this important factor, and then they say his whole judgment something of a puzzle. Paragraph 19, if it's the defendant's duty to measure noise levels in place where his employers work, and he does not do so, it hardly lies in his mouth to assert that the noise levels were not, in fact, excessive. And if a defendant fails to call witnesses at a disposal that could have had evidence relevant to an issue, the defendant runs the risk of relevant adverse findings. Similarly, a defendant who is in breach of duty made it difficult or impossible for a claimant to produce relevant evidence must run the risk of adverse factual findings. In my mind, this is such a case. And they find that the judge failed to give adequate consideration to that.
A reference to the famous case of Emery and Delamere.
Yes. Yes.
Oh, yes.
Now, how does that case help us here? Well, in my submission, not at all. It's not that we have failed in breach of duty not to record something, which has then made it incredibly difficult for the claimant to succeed in their case. I have little doubt, although I don't know because we haven't looked for them, a little doubt that the records of the cancer patient and the cord compression case patient exist. If we look for them, we'd no doubt find them. But we were never asked to find them. And indeed, the pleaded case was they were irrelevant because they were in an 11:30 to 2 slot, whereas the claimant's pleaded case was 09:18. And is it seriously then suggested that we should have disclosed, without being asked, all the patients in the outpatient list between 9 o'clock and 11:30? We don't, there's no general duty of disclosure of all these things until we're asked.
It's rather ironic because if you had not put in any evidence from Dr. Mackenzie, you no doubt have been attacked for not even trying to put in any evidence from Dr. Mackenzie.
Absolutely.
Now, when you do put in evidence from Dr. Mackenzie,
yes,
it said it should have no weight attached to it.
Yes, absolutely, even though it's consistent with all the other evidence. So,
yes.
Where does that get us in relation to adverse inferences? The other aspect of this is, and the judge referred to this in paragraph 64.3 of her judgment, so we looked at 64.1 and 64.2 and the evidence upon which she was able to rely in relation to the fact there would have been a discussion with the radiologist, and it would have been on an urgent basis because it was placed in that slot.
Point.
Was Mr. Thorpe, orthopaedic expert for the claimant, accepted that the time actually taken from orthopaedic acceptance to logging the scan request was reasonable. And that the time taken from the logging of the scan request to the availability of the images was reasonable. So therefore his evidence, Dr. Mackenzie's evidence, wasn't really that contentious, is what the judge was saying, because it had been dealt with urgently, because Mr. Thorpe had said, well, actually, although it was an urgent case, it was dealt with reasonably. Now, my lord, I could take your lordship to the passage where Mr. Thorpe deals with this, but my learned friend helpfully accepted, I think from Lady Mrs. Laing yesterday, that he absolutely accepted that Mr. Thorpe had agreed that the time spent from the end of Dr. Kirkby's assessment, which was at 11:20 on the judge's findings, through to the availability of the MRI images themselves, which was at about 2 o'clock, 10 minutes after the MRI had finished at 13:50, that time was reasonable. Now, given Mr. Thorpe's concession in relation to that, and I ought to just take you to one more thing. So I'm sorry, I will take you to one aspect of Mr. Thorpe's evidence, which is in the grey bundle at 271. At the bottom of 271, the judge asked him, you do have Mr. Langdon's evidence from yesterday that he struggles to see, even on alternative scenarios, how this could have been in his hospital setting done any sooner. This is the scan. And that he would have told Dr. Kirkby to go up and sort it out. We've seen that evidence. Answer from Mr. Thorpe, I'm sure the cord compression that Mr. Langdon referred to in the cauda equina case are a moot point. If Mr. Langdon says that he would not have sought to prioritise Mr. Hewes above the spinal cord compression, then I have to accept his evidence. Top of page 272. A.
You said a little while ago, Mr. Hutton, that it was only priority as against the cord compression case that was an issue, because the cancer case, it was too late.
Yes.
I haven't quite understood those timings.
Yes, so the cancer case was, and it comes from Miss Devereux's evidence. The cancer case was, if I can just turn it up again, was, sorry, we go back to charcoal one, Miss Devereux's evidence, which is at tab 8. Paragraph 9. The cancer case, the request for the scan was made at 11:11, and the patient's details were entered onto Chris at 11:34. So that's 41336, sorry. Yeah, that was clarified that she went to the scan at 11:34. So that would have been after the conversation between Dr. Mackenzie and the radiologist. The bleep being at 11:27. She was being scanned at 11:34.
Mr. Hewes was accepted onto the scan list at 11:59.
11:59.
So by that stage, the
By
cancer
that
patient
stage,
had
she
already
was-
been scanned.
Yeah. Yeah, she was already being scanned. She probably was finished scanning by then. Is that right?
Is that right, based on what Louise said?
Yes, you attend at 6 minutes before the scan starts. Well, that's certainly what happened with Mr. Hewes.
And how long does a scan take?
So the first images in Mr. Hewes' case were 13:33, and he'd finished by 13:50. So about 15, 17 minutes.
Yes, I see. So Mr. Devereux says at the end of paragraph 12, the entire process would normally take around half an hour.
Yes. But there'd also be, when you attend, you get taken through the form and warned about various things.
Yes,
Immediately
well, I think that's
before
what
you
she's
go in.
explaining
Yeah,
in
exactly.
paragraph 12.
Whereas the cord compression person, the request was made at 11:30, and the details were entered into the CRIS system at 12:21. Sorry? Yes, sorry. It's helpfully, it's pointed out to me, paragraph 47 of our skeleton. So the cancer patient, scan logged, request logged at 11:11, moved to attend status at 11:34. Whereas the cord compression patient, P2, Scan logged 11:30, moved to a 10 status at 12:21. And a 10 status is about 6 minutes before the scan starts, and you're actually there. Yes.
The point is the one in 48. By the time Mr. Hewes' scan request was logged at 11:59, the cancer patient was already being scanned.
Yes.
So it's only a question, provided that time, 11:59 is not negligent.
Yes.
But it's only a question of priority over
Yes.
the cord compression.
And to be fair to my learned friend, if we take into account D2's negligence, the 19 minutes from the ambulance, so we take that 15 minutes before, but 19 minutes before, but you're still after 11:34. So you have the evidence in relation to that issue, in relation to the cord compression case, where Mr. Langdon says, well, actually, I wouldn't have argued with a prioritisation for the cord compression first, and Mr. Thorpe saying, I accept that evidence. Doesn't suggest that it would have been wrong in any way. He just accepts that evidence. In which case, what is their case on negligent prioritisation? There doesn't seem to be one. They've not produced expert radiological evidence that it was a negligent decision not to bump the cord compression in order to get Mr. Hewes in first. They've simply turned up on the appeal and said, oh, it was all jolly unfair because we didn't have the records, which they never requested. And we've got Mr. Thorpe's evidence that the whole process from 11:20 right through until 2 p.m. when the images become available, that is not unreasonable. And I suspect, maybe wrong, but we suspect that the reason why my learned friend is seeking to attack the judge's characterisation at paragraph 36, that this is really reasonableness, is because their own expert has agreed it's reasonable. And that provides a major problem for them. So they have to go behind their own expert and say, oh yes, well, our experts agreed that it's reasonable, but it wasn't. And they've got no other evidence to suggest that it's unreasonable. It doesn't exist. They relied on Mr. Thorpe for this point, and Mr. Thorpe conceded in cross-examination. So in paragraph 37 of their skeleton, they say, opinion evidence about reasonable timescale is not determinative. Well, it's not completely determinative because, as we know on Belitho, a judge always, with opinion expert evidence, has always got to test that evidence and come to her own view. But it's pretty important evidence, and she accepts it. So that appears to be it on ground 4. On ground 5, this is factual causation against the first defendant. It is worth turning up paragraph 78 of the judge's judgment on this point. Now, it is, of course, the case, as was raised yesterday, that the judge didn't need to make findings on factual causation because she'd dismissed breach of duty. Oh, sorry, I should have said, before I just move on to that point, in relation to ground 4, I don't know whether my learned friend is, in effect, seeking an order from this court that the judge's finding that there was no breach of duty should be reversed against the first defendant. And if so, when he says the breach of duty was. Because it's not clear as to when he says it occurred. In other words, the scan should have taken place no later than X time. It's not quite as simple in terms of dividing it as against the third defendant, because the third defendant was either in breach of duty and failing to refer to the orthopaedic department or not. But here, she's got to make findings as to when we became in breach of duty.
I thought the pleaded case had identified the time.
0918 for the scan. That was their pleaded case. Their case has moved on from there because the argument that's put forward is purely in relation to the 11:30 to 2 p.m. slot. So we're in that period, not in relation to the period before that, where the outpatients are being scanned. But Malone and Friend needs to identify, is he inviting this court to make a finding, to reverse her finding there was no breach, to make a finding itself that there was a breach of duty by the first defendant, and if so, when? And that hasn't been addressed as far as I can see. Because it's crucial, of course, for the next section, which I was just coming on to, the factual causation. And they're inextricably linked, those two, in our case. Because you have to identify when the breach occurred. When should the MRI have been? When should the surgery have taken place? And when should the decompression have taken place? No doubt Malone and Friend will clarify as to what he's seeking. Is he seeking a reversal of her decision, or is he seeking that this issue is remitted to another judge?
I understood him say he's seeking a reversal of her decision.
Yes. Well, that's what we've always understood in relation to this. But he then needs to identify when. When was the breach? In relation to factual causation, paragraph 78, it is true that the judge has dealt with factual causation relatively briefly. But one must recall that in the light of Mr. Thorpe's concession, as she sets out in paragraph 78, that the timings involved in this case were reasonable in terms of getting the scan, and there was never any allegation that there was any breach of duty before Dr. Kirkby had finished her assessment, which the judge found was at 11:20. No breach of duty by the first defendant. That one gets to 2 p.m. on that basis, on her findings. And then she has to decide, in the light of that, from the time that the images were available to the time that surgery should have taken place. And she has decided in relation to that she says in paragraph 78, in the middle of that paragraph, it would take another 90 minutes to prepare the patient for surgery, including anaesthetic induction, and the time to reach decompression was variable, potentially 60 to 90 minutes. So if you add on 150 minutes or 180 minutes, those two timings added together, you get well beyond 3 p.m. And that's a significant time because that's the cutoff in terms of causation.
But then we still have to bring into play Mr. Booth's point is, just because the overall that time may be
yes,
reasonable, looked at in the abstract, still you have to ask within that.
Yes.
Could it reasonably have been done quicker?
Yes, but he doesn't.
Now, you accept that as a matter of general principle.
I do accept that, but he hasn't identified which bit could have been done quicker.
Using a yardstick of reasonableness.
Yes. It may be, and it comes from his timelines, that his case is limited to this extent to we should have bumped the cord compression case out of the way and been done before the cord compression case. And it may be helpful in that regard to look at his timelines. which Mr. Antelm dealt with briefly, but Mr. Booth just referred to without taking the court to. So in relation to that, there at the back of his skeleton argument, tab 7 in the bundle. At page 89, we start. And at page 90, we see at number 8, MRI attend status. And it says if patient 1 is bumped, MRI attend status would be 11:52. Well, that is flawed because patient 1 was being scanned at 11:34. So that the left-hand column, I would suggest you just ignore. So the right-hand column says 12:21 if patient 1 not bumped, but assumes patient 2 would have been bumped. You would then have got to an MRI starting at 12:27. The MRI took 18 minutes, 12:45. Available on PACS within 10 minutes, yes, 12:55. Preparation for theatre, induction, transfer to theatre, and operation. So those 3 steps. And steps 12 and 13, the judge found would have taken 90 minutes between them. And step 14 would have taken between 90 and 120 minutes.
I thought it was 60 to 90.
Oh, sorry. Yeah, absolutely. 60 to 90. I'm sorry. I'm trying to do too much. Yeah. So 90 minutes for 12 and 13, and then 60 to 90 for 14. Now, if you use the right-hand column and assume that the cord compression case has been bumped and that Mr. Hewes has got in before the cord compression case, then if you use the judge's timings, paragraph 12, instead of prep for theatre, she would have been 13:55, not 13:25. Induction for transfer to theatre 13 would be 14:25. In other words, she's allowed 30 minutes more than they have for those 2 steps. 14:25 at 13. And if you allow then 60 minutes for the decompression, instead of their 14:55, you get 15:25.
After 3 o'clock.
After 3 o'clock. And if you allow 90 minutes, you're 15:55. So you're well after 3 o'clock. So, I mean, I adopt all that my learned friend Mr. Antelm says about the timeline, certainly in relation to the D1 and D3 case together, which appears at page 93, which has all the difficulties that Mr. Antelm highlighted about uncertainties, etc. But if you just look at the case in isolation against us, if the judge's times are for surgery are right, the claimant fails anyway, even if they succeed in their breach of duty case, that the cord compression case should have been bumped out of the way and done third instead. Now, in relation to the evidence on how long the timings would be for prep for theatre and decompression, can I deal with it briefly because I know that time is getting on? But the evidence was that Mr. Thorpe himself, the claimant's orthopaedic expert, agreed 60 minutes in his report, paragraph 6.10 at the charcoal bundle, tab 12, page 88. He agreed 60 minutes for that process and 30 minutes to anaesthetise, so 90 minutes, in accordance with what the judge said. The neurosurgeons, Mr. Crocker and Mr. Mannion, in their joint statement, also agreed the same timescale, 90 minutes. Tab 24, page 271 of the charcoal bundle. Mr. Cowie actually said it would have taken 2 hours, so he was higher. She took 90 minutes for those 2 steps together, prep and anaesthetic. And then in relation to the time it would have taken to decompress, Mr. Langdon in evidence, in the grey bundle at page 196 F to H, said that he'd done 2 recent cases. One took 45 minutes to decompress, so from the start of the operation to effective decompression, 45 minutes. One took 2.5 hours. So that was his evidence. He, of course, on the claimant's case, would have been doing the surgery. Mr. Crocker and Mr. Cowie agreed that the decompression from the start of the operation would take 90 minutes. That was in their joint statement, S1, tab 24, page 272. And Mr. Thorpe, in his report, at the grey bundle supplementary, the charcoal bundle supplementary 1, tab 12, page 91, he said 30 to 60 minutes to decompress, but then in evidence, in oral evidence, he said 30 minutes. And the reference for that is the supplementary bundle 2, tab 11, page 285, because he said he would have used a Midas drill and that would have been much quicker. I don't want to go into that because the other experts were concerned about the Midas drill, thought that it was a bit too vigorous in terms of surgery. But he changed his case where he certainly adopted 30 minutes. So the judge's 90 minutes for stage 1, prep for theatre and anaesthetic, is in accordance with what Mr. Thorpe has said in his report, and also by what Crocker and Mannion had agreed, and less than what Mr. Cowie had suggested. And in relation to the decompression of 60 to 90 minutes, Crocker and Cowie had agreed 90 minutes. Mr. Langdon had given that wide range, and Mr. Thorpe had said 30 to 60 minutes.
And we can be pretty confident Mr. Langdon would not have used a Midas drill.
I think that's right, because he, as Mr. Antelm said, he was a very new consultant who'd not done one of these operations before.
Yeah. The judge at 78 said the time taken to reach decompression was variable, potentially 60 to 90 minutes.
Yes.
Is that quite accurate? Because could it have been potentially 30 to 90 minutes?
It could have been potentially 30 to 90 minutes. I think that's right, because Mr. Thorpe gave evidence of 30 minutes.
Or possibly 30 minutes to 2 hours, but
yes.
Anyway.
And Mr. Cowie relied on the actual operation, which Queen Square had done that night, where the whole operation from start to finish had taken 2 hours, which it was agreed that 30 minutes would have been closing up, so it would have been 90 minutes to decompression. So the judge's finding of 60 to 90 minutes.
Maybe the judge was simply taking the applicable range.
Yes, absolutely. Mr. Thorpe was an outlier in relation to that, but only in his oral evidence.
So she was taking a reasonable range from the range of evidence.
Exactly.
Absolutely.
And that's probably what she was saying. Yeah.
That's what
So 2 hours was taken out and 30 minutes was taken out.
Yeah. Yes.
Okay.
And all that then I think deals with what we have to say about ground 5, factual causation. Then we come on to ground 6, which is legal causation, and the medical issues that the judge had to resolve between the 3 eminent neurosurgeons, Mr. Mannion for the claimant, and Messrs. Crocker and Cowie for the 2 defendants. Mr. Crocker was the first defendant's expert, and Mr. Cowie was the 3rd defendant's expert. This is, we would suggest, a very difficult task for the claimant to embark on an appeal for all the reasons that we have said. This is absolutely in the province of evaluative judgments of expert evidence by a judge. She had a large amount of material, a lot more in terms of literature than we even have in our bundle. She obviously had the benefit of hearing the oral evidence of those three eminent neurosurgeons, and she had to make a judgment as to not necessarily simply which ones she preferred, but which ones she was more persuaded by. She could, I suppose, have tried to steer a middle course, but really there wasn't a middle course here, because one expert was saying that Mr. Hewes was not in CSR at 1203, and indeed not until 1500, and Mr. Crocker and Mr. Cowie was saying that he had reached that stage at least by 1203 and possibly earlier. That was a matter for her as to who she preferred. She has set out her reasons for her conclusions. They are, in our submission, based on the evidence that she heard and her evaluative judgments of which parts she accepted and which parts she didn't. There was, of course, a good deal of agreement between the experts. They agreed that the condition was progressive. They agreed that there would come a point where it was too late to reverse the effects of the claimant's cauda equina syndrome, and there would be significant permanent nerve damage. They all agreed that that point was reached at some point on the 12th of March, before surgery happened at 2300 at Queen Square that day. Mr. Mannion's case, Mr. Mannion's argument was that that point had been reached at 1500 at about the time that he was catheterized. Mrs. Crocker and Cowie said that it had probably been reached during the morning, but was already, in any event, reached by the time of the bladder scan at 1203, which showed urinary retention, 621 mils, with a normal range of about 300 to 400, with not only no urge to void void, but also no ability to void, because he was invited to do so by the nurse and was unable to do so. There, at that stage, they say he had an insensate bladder which was paralysed. She preferred Mr. Crocker and Mr. Cowie's analysis. She didn't do so just because it was 2 against 1 on this issue.
No, she was careful to make that clear.
She made that very clear. And on appeal, the task that faces my learned friend is, you know, as has been referred in relation to Henderson and Foxworth, she's not only, whether the appellant court considers that it would have reached a different conclusion is not the issue. The issue is whether the decision under appeal is one that no reasonable judge could have reached. We submit that the claimant comes nowhere near to satisfying that very stringent test. May I start by going to Mr. Mannion's report?
Before we do that,
yes.
What do you say about the judge's recording what had been agreed, as set out in paragraph 85?
Yes. Well, that was in the joint statement as agreed. And as I'll attempt to demonstrate, that definition came, in fact, primarily from Mr. Mannion, and it came from his report, which then the other experts agreed in the joint statement.
And when one sees what's said about CES incomplete, patients have CS symptoms and signs of concordant imaging but have not lost executive control over the bladder and bowel function, right?
Yes.
Then CES complete, these patients have complete loss of bladder function. Is one to write in the word complete in the first definition but have not lost complete executive control? Or is that, or
well,
I just want to be too nitpicky.
No,
but
they retain control. So you're going to have symptoms of, you know, it may be that you've got incomplete voiding of the bladder. It may be that you're straining to void the bladder. It may be that you've got dribbling from the bladder rather than a proper flow. All those symptoms are indicative in this context of CESI.
I see.
What Mr. Hewes had was a loss of executive control. He had no control at all. He had, the evidence was, he believes that he would have voided at 1 o'clock in the morning before he went to bed the night before. He woke up at 5 o'clock roughly. He did not, having not slept very much, he had the symptoms in terms of his saddle anesthesia and lack of feeling around the testicles, as has been explained. He never had any urge to urinate during the whole day. And so he never appears to have gone through the CES incomplete, certainly in terms of his symptoms. It's not that these symptoms gradually got worse and he found it more and more hard to strain or whatever. He simply never had any desire from 5 o'clock in the morning to urinate.
And then he'd lost any sense of the bladder.
Yes.
At that early stage.
Yes, absolutely. But what is we say there's two things come out of that. Firstly, what Messrs. Crocker and Cowie said is that shows the severity of the compression, because he's not gone through that preliminary stage of struggling to urinate, etc. This is a very severe compression from the start. What they don't say is therefore at 5 a.m. he is CESR in the sense that the nerves can no longer recover. What they then do is say that compression lasts for at least 6 hours, and indeed 7 hours by 12:03. And there is some significance to the fact that the pressure is unrelieved and goes on for 6 hours, because nerves can withstand, as my learned friend said and used the example of the dead arm in the morning, nerves can recover. But after 6 hours, the evidence suggests, they won't recover. That's certainly what Messrs. Crocker and Cowie accepted. So he wouldn't have been irrecoverable at 5 o'clock in the morning, but he was certainly by 12:03. And actually, you know, again, there wasn't so much between the experts, because Mr. Mannion's theory was, well, just because you don't have any feeling and your bladder is paralysed doesn't necessarily mean the die is cast. There will be a period after which that will happen, but you have to identify when that period is. His thesis was, and he relied on the literature for this, you rely on the sign of overflow incontinence to tell you when that moment has been reached that the position is irrecoverable. And overflow incontinence is simply just like, you know, it's like filling up a bottle and overfilling it. The bladder has no sense in it, no ability to void. If you keep drinking, keep producing urine, eventually it will just overcome the bladder. It's so full, and you will start to have incontinence. Now, the significance
the capacity of the bladder is about 1,000, is it?
About 1,000. It can be a bit more, I think. But yes, certainly you wouldn't be surprised at all if you were having bladder incontinence when it was 1,000 mils. It varies, is the answer, I think. But that is essentially what the evidence was in general. The difficulty with that idea of you have to have bladder incontinence, I mean, firstly, you've got the catheterization issue, which prevents the incontinence. But secondly, using that as the marker to say that's the point where it becomes irreversible is an arbitrary marker in many ways, because it depends on a number of other things. Firstly, how full was the bladder before the compression started? If your bladder was empty, it's going to take a lot longer for you to have urinary overflow incontinence. If it was half full or 3/4 full already, it's not going to take very long. Now, that's nothing to do with the pressure of the compression. That's happenstance.
When he voided at 1 o'clock in the morning,
Yes.
was the evidence that that would empty it completely, or not?
There was no suggestion otherwise. Yes, I mean, I think that's the evidence. I think everyone assumed that because, in effect, what he said was, I always urinate just before I go to bed, and I did on this occasion, which suggests that it was just routine at that stage. There was no problem.
And that fits with him having 621 millilitres at 12:03 and,
Yes.
and a fill rate of about 50 to 60 millilitres an hour.
That's right. Which everyone agreed was right, including Mr. Mannion. So the first thing that the overflow incontinence marker, the weakness of it, is how full was it to start off with. The second is how much liquid you take on board. If you drink a lot of water, obviously, or some other liquid, then it's going to fill up more quickly. And then the third thing is about catheterization, is that Mr. Mannion says, well, the cut-off really comes here when he was catheterized at just before 3 o'clock. But that's a bit difficult to understand on a logical basis, because actually he probably should have been catheterized at 12:03. He wasn't, in fact. The hospital didn't do it. But he had 621 mils in there, and he was unable to void. So if we'd catheterized at 12:03, which we might have done, then on Mr. Mannion's theory, he would have been beyond repair. Now that doesn't make sense in my submission as compared to 3 o'clock. So although the overflow incontinence requirement, I don't say it was of no value, because it was an attempt to measure how long you had been compressed for, to understand that if that compression had lasted too long, the nerve damage was irreversible. But it had such arbitrary elements in it that it was unsatisfactory, and it's a point that Lady Justice Laing pointed out when looking at one of the papers, I think it was the Srikang-Daraja paper, was that they said this is unsatisfactory, but we haven't got anything better. So that the Cowie and Crocker approach, if I can call it that, was not to be too rigid on the literature, because the literature was actually relatively inexact and unhelpful as to when the cut-off came. So you had to look at the individual patient to see, well, what was going on with this patient, to see whether it's likely that the nerves would have recovered. And the judges criticised in this appeal that she didn't pay sufficient heed to the literature, that she said indeed that she didn't find it particularly helpful. But in relation to that, can I just take the court to one piece of literature which I say supports the argument that the literature was of limited value in this case. And it's in the charcoal bundle at tab 35. It's the article by Mr. Todd, page 330. Mr. Todd is a very well-known medico-legal neurosurgery expert. And he wrote a review article in 2015, which is later than most of the papers in this bundle, called Neurological Deterioration in Cauda equina Syndrome is Probably Progressive and Continuous Implications for Clinical Management. And he said this over the page 331. He says, sorry, I should have said in the introduction at 330, the bottom of the introduction section on the left-hand column of 330, last sentence, the purpose of this study is to determine what factors probably influence outcome in patients with CES and implications for clinical management. And then the methods were, I'll come back to that, but there were studies that he reviewed, and he found under results, right-hand column of 330, there were 3528 abstracts. So a lot of studies had been done. And at page 331, under the heading Human Studies, on the left-hand column towards the bottom, he said this: a number of human studies have been reported. These studies are retrospective, observational studies of low power, providing evidence that is no better than level 4. There are no randomised controlled trials or case-controlled studies, and there never will be, because it would be unethical to randomise patients to delayed treatment, which is a fair point. The studies are largely based upon retrospective reviews of medical records. The key data is often recorded by a junior doctor as an emergency in the middle of the night, where the quality of the data is poor. When we try to compare the data from different studies, we face the obstacle that the populations are heterogeneous and uncorrected variables limit our ability to compare the different studies and to generalise any conclusions. These variables include the following different definitions of CES: failure to subclassify into CESS, CESI, or CESR, different patient demographics, etc., type of surgery, experience of surgeon, etc., etc., etc. So those are the limits, and then over the page, at page 332, left-hand column, just above the discussion section, the last paragraph, the first hole punch, the human studies to date are limited, contain small patient numbers, are poorly described, and contain many known and unknown confounders. Overall, there is a poor basis for evidence-based conclusions. Some studies have shown a trend to better outcomes with earlier surgery after CESR, but there is no proof. However, equally, there is no proof that delayed surgery does not have a harmful effect. No study has suggested disbenefit to earlier treatment. The human data acquired so far has been analysed by different groups in different ways, and we are no nearer to finding the final answer as to when we should operate on patients with CESR. There probably never will be an answer to this question from the existing human data. So the judge's conclusion that the literature was of limited benefit was well founded, we submit. And indeed,
what's the connection between an insensate bladder,
yes,
and the ability to retain control?
So as I understand it, it's the same nerve bundle is involved, but there may be different nerves controlling the kind of the motor element of it and the sense element. And I probably explained that very badly.
So if bladder control is lost,
yes,
it does not necessarily mean that it's insensate?
No, because insensate obviously means you can feel it. So you could have, it's described as painless urinary incontinence. Retention, sorry. Painless urinary retention. And that is what it's agreed that Mr. Hewes had at 1203. In cauda equina syndrome, that's what you get. You don't get painful urinary retention.
But you can have painful urinary
You can have it
retention.
from other conditions.
Well, in CESI you can have.
Right.
I think the first.
I was looking at the definition of Mr. Todd at the top of page 330,
Yes.
right, top right-hand column.
Yes, absolutely. So CESS, bilateral radiculopathy without CES, CESI, incomplete CES, sphincter problems with objective evidence of CES, bladder control retained, CESR, the paralysed insensate bladder leading to incontinence or catheterization.
Is there some unidentified middle position then between bladder control retained and paralysed insensate bladder?
Well, I think that the difficulty is, yes, I mean, paralysed is one thing, insensate is another. Bladder control retained, you can't have bladder control and be paralysed, obviously. So that is one or the other.
Because obviously one of the points made by the defendants here is by 1203, bladder control is not retained.
Absolutely.
Therefore, it is not CESI.
Yes,
that's
exactly.
Putting it very simplistically.
Yes.
On the other hand, we have what Mr. Todd goes on to say at 332.
Yes.
A CSI patient with hesitance of micturition can deteriorate to an insensate bladder and urethra and still be CESI.
Yes, but if you read on in that passage, you say CESI patients have worse bladder function if surgery is delayed, and then he gives some figures for that, and then says CES patients have more deficit the longer they are CESR. One threshold for neurological deficit is CESR threshold. Some say that once the patient has a paralysed, insensate bladder, no longer under executive control, in brackets CESR, well, that was Mr. Hewes at 12:03,
Yes.
there is no longer any urgency for treatment. Some patients will recover function wholly in part, some will not. The timing of surgery does not influence who will or will not recover function, nor to what degree. So, I mean, it was an issue at the trial, was the fact that he clearly, Mr. Hewes at 12:03, had a paralysed, insensate bladder, which was no longer under his control. What he didn't have was, at that stage, overflow incontinence. But that doesn't put him into CESI. Because CESI are partial symptoms where you do retain control, and he didn't retain control.
Do you understand the distinction drawn by Mr. Mannion, cited in paragraph 86 of the judgment, between a biological definition and a working one?
Well, what I think he understands by that, well, I think he means by that, is working definition is guides you when you're in clinical practice as to, presumably, do I need to operate on this person very quickly? Am I going to save any function or not? Whereas biological definition would be a more kind of medical definition for perhaps these purposes. It doesn't guide you into clinical decisions. That's the best I can do, as I understand it, between working definitions and biological definitions. I don't really understand why he calls that a biological, not working condition. It was a biological definition, not a working definition. It was, as I said, his definition.
Maybe what he was getting at was this, that the definitions of CSI and CSR
Yes.
perhaps seem to vary in the literature.
Yes.
So the real question that needs to be asked, certainly from a lawyer's point of view, is, was the position irretrievable at 12:03?
Yes.
That's the real question, isn't it?
Yes. But yes, but the experts had all agreed that if he was in CESR, then it was on the balance of probabilities too late.
I understand that.
Yes.
So, but instead of that's the question I asked. On the balance of probabilities, was it too late for anything effective to be done?
Yes.
Rather than perhaps getting bogged down.
Yes.
That's maybe what Mr. Mannion is trying to get at.
Well, I think to be fair, Mr. Crocker and Mr. Cowie were trying to get at that, because they say, well, you may have this definition, but you've got to look at Mr. Hewes. What did he have? He had a paralysed insensate bladder. Yes, he didn't have overflow incontinence, but so what? He still had a paralysed insensate bladder, and it had been under compression since 5 o'clock in the morning. So they're the ones that go, well, he might not fit the definition that they have in some of the papers, that you have to have overflow incontinence, but so what? He's not CESI. And on the pathophysiological analysis of nerve death within 6 hours, he'd had more than 6 hours, and he'd had a very severe compression.
You said just now, or perhaps I said, was on the balance of probabilities.
Yes.
The position irretrievable at 12:03.
Yes.
Now really, what one has to ask is, was on the balance of probabilities the position retrievable at
Yes.
12:03?
Yes.
I mean, one hates to
Yes.
have civil cases decided on a ruthless application of the burden and standard.
Yeah,
proof,
absolutely.
Strictly.
Yes. No, the burden was on the claimant to
But
prove it. Yes.
judges hate being
Yes.
resorting to that.
Yes.
Right.
In terms then of the, can I just take you to one more paper, which is the Gleave and McFarlane paper that you have been taken to before. There's two of them. The first one is at tab 25, so strictly it's two papers. This is tab 25, page 274, is their first study, the 1990 study, where this is the origin, it seems, of the distinction between CESI and CESR, although they don't use those terms because that wasn't a term in use in 1990. But they do distinguish between patients who have some urinary symptoms, difficulty in flow, etc. And at page 275, left-hand side, about 8-10 lines down, only patients completely unable to void or who had bladder enlargement with dribbling incontinence were included. Now, in terms of Mr. Hewes at 1203, he was completely unable to void, but he didn't have. But it was either or. What I really wanted to go to was at page 276, right at the bottom right-hand column, was this. 3 lines up from the bottom of the right-hand column. The relationship between the onset of cauda equina paralysis and surgery and its effect on recovery is a fascinating aspect of this condition. Presumably, the pathologic factors are pressure and ischemia. So the pressure, ischemia is lack of blood flow. So as a result of the pressure on the nerves, the blood flow doesn't get through. And that's what causes the nerves to be unable to function. And then he says this, they say this, Lewis suggested that 12 hours was the critical time for ischemic damage of a peripheral nerve to become permanent. But later work has suggested that the time may be less than 6 hours. And they cite a paper by Dyke in relation to that. And our experts placed reliance on that in the sense of, yes, it's not instantaneous when you get the compression, but after 6 hours, if the compression is severe enough, then you're not going to get recovery on the balance of probabilities.
Oh, I see. So they say common orthopaedic experience working with tourniquets, neurological deficit can develop after as little as 2 to 3 hours.
Yes.
Right.
Now, of course, it's always difficult because you don't have 20/20 vision as to what the extent of the compression is in any individual patient. But what the Messrs. Crocker and Cowie rely on is, as I say, the sudden onset of apparently complete failure to feel anything in the bladder at 5 o'clock. And this was not a slowly developing process. And then in the Gleave and McFarlane paper at tab 26, which is the 2002 paper, at page, this is their sort of follow-up paper 12 years later, and at page 281, right-hand column, 4 lines down on the right-hand column, 281. However, there was a significant advantage in treating patients within 48 hours of compression versus more than 2 days after onset. Sensory, motor, and sphincter function were all improved by early decompression. The surprising question raised by this analysis is that if earlier surgery is truly a benefit in CESR, why were the results not improved by operating within 12 to 24 hours rather than 24 to 48 hours? The answer is probably because, once again, this study did not clearly distinguish complete from incomplete lesions. We believe that the likely explanation for the paradox is that the delay worsened the outcome of patients with CESI, but that once CESR had occurred, the timing of the operation had no influence on outcome. This is in keeping with the physiological studies of ischemia on peripheral nerve fibres. Early work by Lewis suggested 12 hours was the critical time for ischemic damage of peripheral nerve damage to become permanent, but later work has shown it may be less than 6 hours. Both studies relate to peripheral nerves rather than nerve roots, which are likely to be less resilient still, as suggested by Stevenson's work in monkeys. My lord, I note the time. I have got a little bit more to deal with in relation to medical causation.
Yes, and you got to deal with anal tone and
I've got
perianal
to do exactly.
sensory.
Yes.
How much longer do you think it'll be?
Half an hour.
Can I write that down in my book? Half an hour, all right?
Half an hour.
Half an hour.
Yes.
And then obviously, Mr. Booth, you'll have the
Indeed, my Lord.
right of reply.
I'm very grateful. My Lord, just to be absolutely comprehensive, I handed up to your Lordships and your Ladyship a Queen's Bench
Yes,
copy of Wright and Cambridge Medical.
thank you. I was studying that over the
Back-
shorter German. So
back of
that's,
the green
that's,
file.
thank you very much indeed. If it's 10:30 tomorrow morning, convenient for everybody in court?
Yes.
Yes, I think 10:30. I'll start again at 10:30 tomorrow. Thank you.
Compliance.